Do not go to your grandmother's house if you are released and cause problems for her, because she does not need any trauma or drama coming to her doorstep. You understand?
Yes, Your Honor.
And if you're going to be staying with her, guess what? You're not an adult. You need to follow her rules. If she tells you she wants the television off by 10, that TV needs to be off by 10. If she tells you she doesn't want any of your friends coming over, then your friends can't come over, because that's not your house. That's her house. You are now an adult. You understand? All right. You ready? We're going to go back on the record in 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state? Okay. And with regards to the waivers and stipulation of testimony and stipulation, state, any additions?
Yes, Your Honor. We would like to, add Stacy to the one to add the prosecution side. Given the defense that they would.
Any objection?
Your Honor, we have no objections.
All right. And you understand what's being added, Mr. Aguilar? All right. The court will find, based upon state's exhibits 1 and attachments and the stipulations what the court has is accepting the record, and the court is finding that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will find there's sufficient evidence to find the defendant guilty. The court will defer finding of guilt because the defendant has applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client? So how old are you? Do you have any children? All right. Any drug issues for you? Are you employed? Have you ever been employed?
Yes, Your Honor.
Doing what?
Working at a restaurant, going on painting, remodeling,
All right. And how far did you go in school?
high school.
Did you graduate? Why not?
I got into a program and learning academy and I felt so I can go to work.
Okay. All right. And I see that he is a resident and not a citizen. All right. So whether or not the federal government removes you, that's under their purview. That is not my purview. I do not have any control over that. Do you understand?
Yes, Your Honor.
And legally, I cannot remove you. You understand? All right.
Judge,
Yes. Mhm.
there are proceedings. Here that.
So does he have a hold?
He has a hold, but he's released on the bond.
All right. There's going to be a $500 fine. That will be probated. 8 years deferred adjudication. There's to be no contact with Emmanuel Nathaniel Morley, Morley Jr. There's to be no contact with Charles Williams. There's to be the theft course and the MRT course. Is there any restitution that's due to the complainant?
No, Your Honor.
There should be regular reporting by Zoom or in person, regular UAs. If you were released, who are you living with?
Okay, well,
All right. So probation,
Yes, Your Honor.
if he is released by the federal government and they put him on the monitor, then it's fine for us to just have him on that monitor. But if he is not released without a monitor, then we will put him on a monitor. And that will be 90 days GPS. and it'll be partial for work. There's to be 200 hours of community service restitution. Those hours will be waived if you obtain your GED or if you're in some sort of trade school. You need to have some sort of skill so that you can have employment. You understand? And you say you're residing with your grandmother. Does your grandmother want you residing with her? Did you ask her?
Already, when I came from immigration, that's what my had to say.
Okay. Defendant to reside with grandmother. Is that your maternal grandmother or paternal grandmother? Is it your mother's mother or your father's? Okay. So he's to reside with his maternal grandmother upon verification. There's to be proof of employment. Within 40 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs?
Your Honor, do you want any field visits?
Yes. Let's do field visits. One time per month for 3 months. And then if probation feels that everything is going as it should be, then you can do those randomly. All right, is there anything else, probation?
No, Your Honor.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Look, you're a resident. Maybe they're going to deport you. Maybe they will not deport you. But while you are here, you need to do better. You understand?
Yes, Your Honor.
People already have an eye on you because you're a resident and you're not a citizen. You make it harder for other people when they are residents and they're doing the right thing. Because then people are, there goes another resident who's committing an offense. There goes somebody who's not a citizen who's committing an offense. And you make sure that people are able to paint a brush that residents and that people who are not here are not doing what they're supposed to do and are not being law-abiding people. Do you understand?
Yes, Your Honor.
You're going to have to do better. You understand?
Yes, Your Honor.
And do not go to your grandmother's house if you are released and cause problems for her, because she does not need any trauma or drama coming to her doorstep. You understand?
Yes, Your Honor.
And if you're going to be staying with her, guess what? You're not an adult. You need to follow her rules. If she tells you she wants the television off by 10, that TV needs to be off by 10. If she tells you she doesn't want any of your friends coming over, then your friends can't come over because that's not your house. That's her house. You are now an adult. You understand?
Yes, Your Honor.
All right, do better. Good luck to you.
Thank you, Your Honor.
Oh, by the way, do you need anything else from the court?
No, Your Honor.
All right, what's that? I just noticed. What's that tattoo on your hand?
What are you saying?
All right, do a gang evaluation as well, please.
Yes, Your Honor.
All right. Thank you.
Thank you, Judge.
Motion to enter adjudication. Excuse me. Mr. Ross, no talking behind the court reporter. Just ask the deputies, they'll move you to the other end. Oh, no problem. All right, we're back on the record. Mr. Flores, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? You need to speak up.
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Omar Flores who was placed on deferred adjudication in 2024 CR 2669 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on June 13th, 2024 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
On or about the 5th day of August 2024 in Bexar County, Texas, the defendant Omar H. Flores did then and there fail to complete the substance abuse treatment facility with the BCC SCD in that the defendant refused to sign amended conditions to attend as directed by the supervision officer and or the court in violation of condition number 39.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 39, the court can find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
Court will find violation of condition number 39 true. Is there a proposed agreement?
Yes, Your Honor. Adjudicate guilt, revoke supervision, assess punishment under 1244A at 200 days of confinement in the county jail.
I'm not going to follow that proposed agreement. Why
Good.
should I follow that?
Let me give you a little context
Yes.
of why he refused to, first he got denied for felony drug court, Judge.
Mhm.
They were at capacity and whatever reason, I don't know why he didn't qualify for it.
Mhm.
He's got 5 children under 8. And his wife was late in the pregnancy when he's been in custody since May 20th, Judge. And so he was in custody when he entered his initial plea. Once he realized that he's gonna have to wait for a bed and being saddened, he didn't want to be, all his thinking is he didn't want to be away from his family that long and potentially miss the
Wait, you're
birth.
saying he's been in custody since May?
Yes, Judge. He's been in nonstop custody since before he took the plea, back in, I believe it was June that he took the
All
plea.
right, so we're not going to count that part. How long is he? He took the plea June 13th. So he's been in custody since June?
Well, he was in custody before he took the plea.
Well, I'm not even going to consider the time that he's been in custody before he took the plea. All right, so he's been in custody since June, when I ordered felony drug court, and he didn't qualify for felony drug court?
Correct, Judge.
All right, probation, why is it that he didn't qualify for felony drug court?
He did not meet the criteria for substance dependence. Based on self-report, he didn't meet the criteria for such.
All right, so,
Felony drug court at the time was also active.
all right, felony drug court was at capacity, and he said he didn't have a drug problem. And part of the reason why you were in custody, you say since May, is because April you had a court date and you did not show, so a BF was issued, so you were remanded without bond. So that's on you. You didn't appear. And felony drug court didn't accept you because you said you didn't have a problem and they were at capacity. All right, so you may continue.
Judge, the way he's thinking is, I just got to get home to my family as soon as I can. And so, when they're talking around the jail and hearing he's going to be waiting months for a bed, he just, for whatever reason, he didn't want to do that. And he wasn't going to be able to visit his family when he was at SADF. He wouldn't be able to see them. And so that was very important to him because he can have visits at the Bexar County Jail. So that's why he didn't go, Judge. Obviously, he probably regrets that now in the situation he is, but we're hoping the court will consider the fact that he's been in jail and custody for so long that's enough punishment for him.
All right, I'm not going to sentence him under 1244. And with regards to his children, I realize he has children. That's why I ordered parenting classes. And I don't know how he expects to help his children or be present in his children's life when he has a drug problem.
Well, Judge, the whole time he's been in here, he's realized the effect he's had. He's never been away from his family, and he missed the birth of his son. So he hadn't even had a chance to hold his son yet, and that's killed him. He's a family man. He loves his kids, and he sees what this has done to his children. He's told me I'm never touching anything again. I don't want to put them through this again. So I believe him, Judge. Now if the court's willing to entertain releasing him back on deferred and maybe giving some outpatient treatment.
Now, what's his criminal history?
As far as I can tell, Your Honor, he doesn't have any.
All right, did you run TCIC, NCIC?
Not today, Your Honor.
All right. Do you have a TCIC, NCIC? Doesn't matter if it was run today. He's been in custody for a while. Do you have that? Do not go to your grandmother's house if you are released and cause problems for her, because she does not need any trauma or drama coming to her doorstep. You understand?
Yes, Your Honor.
And if you're going to be staying with her, guess what? You're not an adult. You need to follow her rules. If she tells you she wants the television off by 10, that TV needs to be off by 10. If she tells you she doesn't want any of your friends coming over, then your friends can't come over because that's not your house. That's her house. You are now an adult. You understand?
Morning, Your Honor.
Good morning.
Thanks.
I guess there's always another year.
Always next year.
Yeah.
I'll be filled with so much hope next August. You bet. Never
Oh,
fails.
like Cornelius, I can't sleep. I'm so excited. We're gonna win a championship. Okay. So on this one, we have a VR. Have you reviewed it?
We've reviewed it. We've spoken with the state judge.
All right, what's going on with this?
I think Mr. Robinson is here to be honest with you, Judge, and let you know that he had a glass of wine on this date with his family.
Why do you think you can drink?
So my father passed away earlier this year. With that, we weren't able to get family together for that aspect of it. So that day we were able to have that, and then they had a toast. So I had that with them. We had it quite a while after.
Well, you know, you're not supposed to drink.
I understand that. I know that we're totally wrong on that aspect. I didn't. Sober since the 22nd of March, still go to meetings. I just had that kind of just to be with the family and honor my father, kind of reminisce.
State, what do you want to do with this violation report?
Garahan. Robeson. Violation report.
Judge, yes, on this particular case, I believe that there was to continue, but also to add the outpatient substance abuse treatment.
Okay,
That's what our recommendation would be, Judge.
all right, I'll waive fees and I'm gonna add 120 sober meetings in 120 days. All right, and where are we on discovery in this case?
I don't recall, Judge. I thought we were just brought here today.
Oh, yeah, it's
Or-
this, but while we're here, we
Okay.
might as well.
I would
see.
have to check with Mr. Sharman on it, Judge.
All right, so it's coming back on December 16th.
I'll be back.
All right, is there anything else?
No, Judge. Thank you very much.
All right, so let me explain something to you. I understand that people have issues. The holidays are very stressful time anyway. But then to add on the fact that your father passed, I understand, you know, to lose someone you love. But you've got to be 100% vigilant and not drink at all. And you need to admit to your family, if you have not, and this is something maybe you can talk to with your therapist and tell them, hey, I can't drink alcohol. You know, whether you think you have an alcohol problem or not, you need to let them know. I'm on bond for this. I can't drink at all. And I guarantee you, if you would have told them that you could not drink at all and they love you, they would have said, hey, you don't have to toast with wine. You can toast with sparkling apple juice or grape juice or whatever. I don't drink because I think it tastes nasty, but that's just me. So whenever people are toasting, I always just grab a Sprite or something, or either apple juice. You understand?
Yes.
All right. Does he need another reset form or no?
No,
And for the state, Your Honor.
Defense?
Caitlin Knowles for Mr. Wallace.
Are you Arthur Wallace?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Arthur Wallace who was placed on deferred adjudication in 2019 CR 11417E for the offense of aggravated robbery on March 12, 2020 for a period of 8 years? Is that you?
Yes.
State?
Yes, Your Honor, violated condition number 1 on or about the 18th day of September 2022 in Bear County, Texas. The defendant, Arthur Wallace, committed the offense of theft, $100 to $750 in violation of condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated conditions.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, find you guilty, sentence you to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, ma'am.
Court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor.
Yes.
It is to deny the motion, continue him on his deferred adjudication, and alter them in to conclude conditions for ISP, weekly reporting for 60 days, and felony theft class level 2. And the state will be taking into consideration calls number 708351 out of County Court 9, and that is the theft that he just pled true to. That theft did happen back in 2022, was sealed, and it was not unsealed until May of 2023, Judge.
So this was not known before this was,
It happened very close to the time, but he's made many strides, as you can see, based on his compliance with probation's UAs and negative. This was a while ago, but he is extremely taking extreme responsibility for this and understands, but he's made so much progress since, but he's still going to answer to this new case, and that's why we're here to plead true.
all right, so this case was not, nobody was aware of it when he was placed on deferred for this?
Well, no, Judge, because I believe he was placed on deferred back in 2020.
Okay.
And that theft happened in 2022. So 2 years after that he was placed on probation.
And so I was saying, Your Honor, he's made many strides in the right direction since then, but he's still taking responsibility for that theft. That theft was a like a groceries I'm providing for his family type theft. It's still wrong. He knows that. But it's just been a while and he's made so much progress since.
All right, probation,
Yes, Judge.
what is your recommendation?
This is the state recommended for him to be placed on intensive supervision. 60 days weekly, 60 days weekly reporting and the theft course, Judge. He has been doing very well on probation, Judge. All of his UAs have been negative. He reports as stated. His field visits have been going well. He finished his parenting class back in 2021. We have not had any issues with the no contacts. He is, he's made a few payments toward his fees. That's something that he does need to work on. And he still needs to complete his community service hours unless the court feels obliged to give him some type of credit for completing with his parenting class, Judge.
All right, do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Arthur Wallace.
All right. So what is the issue with your community service hours?
But me and my officer, he would send me to places until recently, and either they don't take me because of my charge or they're no longer doing community service.
All right, so as a part of your conditions of probation, I stated that I would waive the community service hours if he completed some type of trade school or higher level education. So what are you doing with that?
I in talks with do barber college. I just waiting for the financial paperwork to come back in. In the meantime, I just been working for myself.
Doing what?
I go to different events and I sell food and I also have a community business.
All right, so here's the thing. You can't be waiting for your life to be better. So with that barber college or whatever you're planning on doing, you need to stay on top of that, because otherwise the 200 hours community service you're going to be doing, they will always need people to pick up trash on the freeway. I'm a firm believer that community service hours, you do a service to the community if you better yourself so that we won't see you back here. So I'm giving you a deadline to start on your community service hours. You have, how many have you completed?
I don't really remember. I turned to them last time I was here to probation, and my officer also has an email copy as emails.
Probation does have a copy of that, Your Honor.
All right. This is what the court will do. The court is finding violation of condition number 1 true. The court will follow your agreement. The court will deny the motion, taking consideration 7 08351. The court will order the theft course. Probation, has there been any issues with his reporting?
No, Judge.
All right, that's the court's ruling. Is there anything else?
No.
The TCIC came back and there's no priors.
Okay, all right, the court is back on the record in 2024 CR 2669, State versus Omar Flores. Could I have parties re-announce? State,
Andrew Harris Edelman.
defense?
Scott Hill for Mr. Flores.
All right, he pled true to violation of condition number 39. The court found it true. The court asked the state to pull the NCIC TCIC. State, did you do that?
Yes, Your Honor.
And what are the results?
This is the only case he has.
All right, and what is parties' request with regard to this motion to revoke?
Adjudicate guilt, revoke supervision, assess punishment under 1244A at 200 days of confinement.
Probation, are you in agreement with revocation and the 1244 for Mr. Flores? All right. This is what the court will do, because he hasn't done anything on probation. The court is going to find 39 true. The court will find you guilty, grant the motion, revoke you, sentence you under 1244 to 365 days. And give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
You do have a limited right to appeal. That right to appeal is that as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
Yes, ma'am.
This is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, Judge.
Thank you.
May I be excused?
Yes.
Renee Munoz for the defense.
And are you Mr. Prashnicki?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Are there any applications?
No, Judge.
Mr. Prashnicki, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state moves to proceed on the lesser included offense of possession of a controlled substance, PG 1 less than 1 gram.
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter a plea in this case?
No.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, that is correct.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? Sorry.
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1. They're asking that your punishment be assessed, thank you, at 97 days in the Bexar County Jail under 1244. They're asking that there be $1,000 fine and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
The state offers states exhibit number 1 and attachments.
No objection.
All right, state, you may be excused. Did you review the waiver with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. To find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
All right, anything you wish to say on behalf of your client?
Your Honor, my client has 97 days custody in the Bear County Jail. We ask that the judgment reflect it's satisfied. And due to him having that credit, Your Honor, and my client has learned from this incident and does not wish to repeat it, to remain in this courtroom or any courtroom for that matter ever again, Judge.
All right, what have you learned?
Our life's too short to be messing up all the time.
All right, so why do you continue to do this?
I lost my mother a few years ago, hadn't dealt with it. But I've been doing better.
All right, but that doesn't translate into what you're doing in the park, you understand?
Yes, ma'am.
All right, so obviously you have a drug problem. So how are you planning on solving that? Because I will tell you, people will come before me and they say, I've learned my lesson, I'm never going to do that again. That always happens when you're in custody. But then once you're released, people start to backslide. So what are you doing to make sure that you don't come back again?
Oh, I've reached out to my daughters and they're gonna be more, we're gonna be closer.
All right, but
And I may just change people, places and things and move back home with my dad maybe, or.
all right, here's the thing though. Don't be bringing your problems to your daughters or your dad.
Oh, yes, ma'am.
Sobriety is 100% on you. You can't have your sobriety dependent upon other people.
Mr. Costancio.
Are you Mr. Constancio?
Yes, ma'am.
All right, do you have any objection to this attorney standing in for Miss Kelly Green? Counsel, have you received all discovery?
We have,
Did you review it with your client?
we did.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
There are not.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do?
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Constancio, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense of burglary of a building? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
No, Judge, but he's been able to assist in his defense and I believe he's confident to enter his plea.
And do you believe he was sane at the time of the offense?
I do.
Mr. Constancio, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 9 months in the state jail facility and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Should be contained in Exhibit 1 and attachments, Your Honor.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And there's sufficient evidence to find you guilty. Court will find you guilty. Are you proceeding with sentencing?
Yes, Judge. For the record, the clerk's already verified that he has 142 days credit so far.
All right. Court will find you guilty. The court will sentence you to 9 months in the state jail facility, give you credit for any time served. There's to be no contact with Robert G. Vera, Vera, or 2407 Monterey Street, 78207. And there's to be restitution, if any, to Robert G. Vera. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to change your life. If you don't change your life, you're gonna find yourself living in somebody's prison, in somebody's jail. You understand?
Yes, ma'am.
All right, good luck to you.
Judge, I was gonna ask for Mr. Costanzo whether you'd make a finding he's eligible to participate in programs. He can get there soon enough
Oh,
for it to
well, I will
matter.
tell you what ends up happening
Okay,
is that I automatically get reports
Okay.
on every state jail felony case. So if you're participating in programs, then I will consider giving you extra credit. You understand? All right, so it's up to you. You up to 4 years in prison and up to a $1,500 fine.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes, Your Honor.
Court will find violation of conditions 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor.
And what is that proposed agreement?
That proposed agreement is to grant the state's motion to revoke community supervision, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
Is that your agreement?
That
counsel?
is your, yeah.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement. Sentence you to 3 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Pantandra, Patandra, Booker, Booker. Is there anything else from either side with regards to sentencing?
Not from the state, Judge.
Judge, I believe, Mr. David has something to say.
Yes.
We have a child together, and, the first time that I was here, you said no violent contact. That was the very first thing you said. And, ever since then, it's been.
No, because of what I've written in here is when you were first placed on probation, it was to be no contact with Padandra Booker. Then you had a motion to revoke file. And then that was for a violation of condition number 5. I denied the motion, alternate amend conditions to complete BIP, transfer to Dallas, weekly reporting, the UA hotline. And then in August, this was set for August 24th for a contested hearing in person. And then on August 24th, there was a violation of condition number 15. That judge found it true. And then today, this is where we are. I've never ordered a no harmful or injurious contact. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Look, you're gonna have to change your life. You say you have a child, you want to be in your child's life. I would think that you would want your child to be proud of you. Part of that is stop with your drug use, which alcohol is a drug. If you can't control the uses of it. Be kind to your child's mother, which you have not been. We're here for an assault choking. That means you choked her.
4 years ago. Your Honor.
I mean, that's no excuse. You can't say, oh, I shot somebody, but you know, we're back together. That was 4 years ago. Do not minimize.
In Judge Stephanie Boyd's courtroom, Mario Aguilar stood facing the consequences of his actions. The court found enough evidence to hold him accountable, but instead of prison, he was given 8 years of deferred adjudication. Strict conditions followed: no contact with victims, drug testing, GPS monitoring, community service, and a warning that as a non-citizen, every mistake puts his future in this country at risk. The judge made it clear. This wasn't mercy. It was a final chance to change before everything is lost. Do you think the court made the right call? Like, share, and follow for real courtroom cases.